Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, I'm Charles Hatley from One Hatley PC. This is I Now Pronounce You Divorced, our podcast where each week we talk about issues that are near and dear to our clients, near and dear to us. And as always, I'm joined by Rebecca Malone and Mr. Dan Cunha. This week is part 2 of what we were talking about, the intersection of family law and estate planning. And last week we ended with Dan, you talking about, having a family law attorney who also works in estate planning. Avoiding anybody that says, oh, I specialize in one or the other. And, during our break, it made me think about a case I had when I was a younger attorney where it was a very acrimonious divorce. A child had been adopted. And, in getting the divorce over, I had talked to my client and we had agreed that he would write a trust for his child. This divorce could not have been more acrimonious. I mean, it was I think 7-day divorce trial. And the parties did not have that much by way of assets. They had a house, they had a couple cars, they had a couple retirement accounts, and they had this child who had been adopted, and the child really wanted to go live with my client. And the other parent was really, really mad about that. So my client made the bulk of the money, ended up having to pay spousal support to the other side, which was common, which was expected for that particular case. But then the child came to live with my client, so the spousal support was offset by child support. Unfortunately, my client, who was couldn't be a nicer person, passed away like 4 months later. And we had set up the trust. We had everything finalized. We had put all of his retirement accounts into the trust. He had gotten the house in the divorce. We put the house into the trust. And we put his parents as the trustee, as the person that would control the trust. And the daughter was the beneficiary of the trust. He passed away and the child went to live with the mother, and she was so mad about the ceasing of the spousal support, she was trying to charge the child rent. So she was trying to charge the child, I think he was paid her $2,000 a month in spousal support, $3,000 a month. She was trying to charge the child the same amount of money. And when she wouldn't pay the rent, she made her sleep outside. And the reason I got pulled back into this case is because I was the one that had drafted the trust. And the other side went and sued the child to try to get at the money on the basis that my client had died on purpose, that he had died knowing that he was going to die, like all these theories. And they were just trying their hardest to eat up the money. But we weren't talking about somebody who had a lot of money to begin with. Like Rebecca said, he had a house. He had a house that was sold and put into the trust, and he had some retirement accounts. So, for this child, we set it to when she graduated from college, she would start getting monthly draws off of it to help with her income. That's it. It was going to last her entire life because of the interest that it had accrued and everything. And, that always got me thinking of how wonderful this intersection of family law and divorce can be. So, Dan, have you ever had any situations like that?
That's a unique case.
Yeah.
And it really goes to why you want to make sure that who you hire has that particular knowledge and experience, because although it sounds that fact pattern in that case is an anomaly, it probably isn't compared to how many divorces that are filed and how complex some of these can be. But just listening to that case, to me, that other side was just filing frivolous motions and not in good faith. And hopefully the court recognized that and sanctioned them and awarded fees. But it goes to when you're meeting with potential clients, asking those tough questions. We talked about it in the last podcast, to where that holistic approach. And this is a great example of really what does that mean? You're going through a divorce and you have a trust involved. What can I do to protect my children in there? And you think of these just unique fact patterns that arise, and you're talking to clients and they sometimes probably look at you like a deer in headlights. Oh, there's no way in heck that's ever going to happen, but it does. And once that dust settles, the other side really goes for blood, and it can be going after the assets, going after the money. And the best way to make sure that it's as secure as it can be, or you're protecting your family, you want to make sure that that trust is drafted solid, and making sure that the trust is drafted in good faith, and that you're being open and honest, almost as if someone's coming in and you're wanting to do like a prenup or a postnup. There is that disclosure of assets that has to be involved. But at the end of the day, once you have that trust created, then everything that's involved in the trust and the rules of the trust will govern. It's hard for a court to come back in and essentially undo that trust.
No, it is. You're right. And the trust is what saved my client's intentions in that particular case. And the secondary part of the trust, which I'm going to ask Rebecca to talk about a little bit, we in the trust said that my client would like for his parents to take over parenting for the minor child, for his parents to be the guardian of the minor child. And in Virginia, it's very hard for grandparents to get any sort of custody rights. Not so much visitation is tough too, but custody is really hard. But they enacted a statute that if somebody spoke posthumously, if somebody spoke through a document after they passed away, then their intent could be used as part of the evidence. Rebecca, how do you advise clients on that in acrimonious divorces?
Sure. So you can always say what your wishes are, right? It never hurts to put it out there that this is what I would want if it's possible. And ordinarily, the guardianship provisions aren't going to kick in unless both parents have passed away, because the default choice will be the other biological parent. But giving your chosen people kind of a leg up doesn't hurt, because they can go into court on their petition. And in the case you just talked about, certainly where you can show mom's making her sleep in the backyard, like this is child abuse. So they're going to be able to show actual harm, which is the standard for third-party custody in Virginia. But they also have behind them kind of that support of dad. They're able to show those documents to the judge and say, this is what dad wanted. And so this isn't a situation where, grandparents had been cut off forever or something like that and are just now popping up into the picture. These are grandparents who have been really involved from day one. They have a relationship with this child. They had such a good relationship that dad actually named them as his preferred custodians. And so it's always helpful just to show the intent. And I actually have a client right now where there's a little bit of a limit in terms of like what she wants to do with her trust. She's very, very specific, and that's great. I love it. But there's certain things that we can't necessarily include in the trust, or else it'll be a little overly restrictive and it could be hard to implement if anything changes in the future. So what she's doing is drafting a letter to say, this is kind of what my whole idea is behind this. And she's got some unique provisions in there. So that she's divorced and she wants the house to go to her children. But if she passes away, she wants the trust to continue paying for the house, and she wants to allow dad to live in the house. And she's got some very specific provisions. She wants the kids to be able to travel. She wants them to go to certain other countries. She wants them to participate in certain language programs. And we don't want to completely restrict the trustee's ability to, maybe sign them up for a different trip or different language program or something else along those lines. But she's writing this letter to her trustee to say, this is my intent. This is what I want my kids to experience. These are the reasons for it. And then that way, that's going to help guide the trustee's decisions after she's gone, in order to do what she wanted to.
Yeah. And, I think you brought up a great point. You don't just use a trust when you want to get back at the other side. Like your example was, I want this house to be here. And if I'm not here, I want my children to be able to stay in their home. They've already been through enough. I passed away. We're divorced. I want my children to be able to stay in the home. And I'm asking my ex-spouse to move back into the house, which, it can probably a very nice house, and accommodates everybody. Dan, when you're going through this, what is your best advice for somebody who says, look, I don't want to deal with the estate planning part right now?
Right. And you get that. And it's okay. So if you're going to your doctor and they say, oh, well, you have a heart condition. Well, I'll deal with that later. I just want to talk to you, my GP, my general practitioner, about this little cold that I have. Even though you discover something else because you have the holistic approach with medicine, I'll punt that off later. And then, oh my gosh, now I'm dying because I should have handled this before. So it's you come in and we had that holistic approach, and let's talk about, of course, yeah, here's what the laws are. Here's how the statutes apply to your case. Here's your risk. Here's your reward. I know what your goals are. But now let's take a look at some of these ancillary issues that may or may not arise. But let's address them now and head it off at the past before it becomes an issue. And okay, you have a will. Did you know what this will meant? Do you remember executing this? Do you know who the beneficiaries are? Do you know what the authority is of the will? And then, okay, you don't. So let's walk through what that means. And did you know that there's a trust out there? It's kind of like prescribing medicine. Let's do this to help with some of these issues. So your goal, you had a will because you thought you're protecting your assets. And Rebecca did a marvelous job explaining what the difference is. So, all right, so now we know what your goal is. It's probably not really best that you have the will. Let's talk about what a trust is. And here's a trust. And here are your options under trust. And here is what the risk is if you do revocable versus irrevocable. And here's what we need to implement as far as what does the trust actually, the authority and the powers of the trust, and what assets do you want to put in there, and why do you want to put these assets in there? And what does that mean? And what is your true intention? Going back to what both of you were talking about as far as showing the intent of drafting that document. And then let's go ahead and walk through what that means as your kids get older, and what is the best path forward to make sure we're protecting them, but not usurping what your goals are. And just kind of really laying it out there and just walking them through so they can understand, and then having them come back in for a second meeting, because you're really throwing a lot of information at them. And so you want them to be able to digest it and then have a follow-up to kind of walk through again, now what option works best for you, and let's start that process there.
For me, I find I just start talking about it from the beginning, right? I say, hey, look, medical directed power of attorney, we need to protect you. We need to protect you. And it's very much so a prophylactic measure. And, Rebecca, how do you do it? I mean, how do you handle the rejection part of it being like, we just want more of my money?
Yeah, absolutely. So way back when, I didn't used to do very much estate planning because I thought I could just refer it to somebody else. And so someone would come to me with a divorce and I'd say, great, while we're going through this, we also need to handle your estate plan. Here's so-and-so down the street. They're fabulous. Go to them. They never did. Never, not once. And so I started sort of taking it on myself because we've seen some of these really unfortunate cases. And that's why we've integrated it in with our family law practice to make sure that our clients are protected. And I think when we start talking about it at the beginning, that this is part of your case, like it or not, your heart is part of your body, right? And we're going to have to deal with this as part of your case, whether it's with us, whether it's with somebody else. I don't necessarily care, but we got to make sure that your stuff is handled. And if there's just an adamant refusal throughout the whole process, then that may not be a client that we can necessarily do a lot for, if they're not willing to take our advice and work with us on what they need to do. I've also seen the downside of folks trying to do the do-it-yourself online cheapy, whatever program. And what you don't get is that, yeah, it's easy for you. It's very easy for me to go online and type something out, and then I don't have to think about it ever again and I don't care. But for your family, what you're putting them through and how much more difficult you're making things, it's exponential. It's absurd how much different it is. And I think whenever I've had a client that has personally gone through helping to administer an estate, they're right on board. They understand exactly what goes into it. If they've been part of, their parents' will that had to go through probate, or their parents' trust that they had to administer, or something along those lines, they're like, yes, let's do it. I want to make sure that it's as easy as possible for the next folks that have to come in, because it's a hard enough time when you're dealing with a loss. Now I also have to figure out this whole process, and I have to pay a whole bunch of fees, and I have to now hire an attorney, and there's just layer after layer after layer. So introducing it really early in the case and making sure they understand how integrated it is with their family law case. And then also making sure they are aware of prenup and postnups. So just because you're getting a divorce now doesn't mean you may not, necessarily get married in the future. It might mean you never get married again. That's fine too, right? But if you ever do consider remarriage, you probably don't want to go through this again. And there's another way that's out there. So adding in a prenup or postnuptial agreement going into that new relationship, again, is going to help just make things so much easier down the line.
And, you brought up something that I always discuss with our clients, and I tell them there is a self-help option. And there really is. I mean, I'm not going to try to hide it from anybody. I think, giving somebody the holistic approach, it is out there. But, you kind of covered, look, there are negatives. You made it easy for yourself.
Yeah.
So, Dan, what advice would you give somebody who's trying to make it easy on themselves right now and the benefit of not doing that?
Sure. I mean, you have all these DIY projects that are out there, but you're not going to build your own home, right? I mean, there's no way. And so when you have these clients who come in and they want to save on money, I get it. It makes sense, right? Because this process can be costly, it can be timely, and it's emotionally draining. But you have to try to get them to think the bigger picture, which is what we do now is going to affect down the road, whether that's your case or whether it's what Rebecca was talking about, a prenup or a postnup. Let's try to make this transition a little bit easier for you from a financial standpoint. And how we approach things in the beginning is going to have a substantial effect on how we approach it on the end. And especially clients that come in and they'll say, oh, I print out this form online. Here we go. I got this from LegalZoom and I just need you to review this, right? And it's just, you're looking at it and I get it their side and it makes sense from someone who doesn't practice law, but there's just so much risk involved in that. And sometimes we have clients who come in, they've already made filings with the court because they did it themselves. And it's hard to get out from underneath that. And what you're doing is you're spinning your wheels and you're spending more time and more money to try to get out from underneath something you thought was a good idea because you filled out the form online, but had no idea what the implications were. I always like using medical terminology or examples, right? Because I'm not going to go in and say, oh, I think I need to be prescribed this, so let me take it. But I have no idea what the side effects are or if it's even going to help me. So you're not going to go online and just fill out forms and just arbitrarily file them because you don't know what those effects are. So that's why you want to talk to a lawyer, but you really want to try to prevent clients from doing it themselves because there's just so much that could potentially harm them that they just don't know. And that's the whole point of that initial meeting, and then retaining that firm and having them prepare and draft the filings with your signature and your review of it, but they know what's best. Doctors will know what's best. As you go to a doctor for help, you're going to a lawyer for help. And so that's how I approach it with.
You said something that reminded me of a quote from Gladiator. What we do now echoes into eternity. With estate planning, that what I do now echoes down to my children, down to all my heirs, and it's the problems going to cause them in the future. I hope that this was helpful for you, that you can kind of start to see that, when we talk about estate planning with divorce, we're not talking about just trying to make things more complicated. We're actually talking about, okay, your divorce happened. Let's plan the next 5, 10, 15 years of your life. Let's really plan for your future. One of the things we always say is we protect your family, your finances, and your future in the divorce process. So if you or someone is going through divorce or just needs some help, send them this podcast and hopefully they're able to learn something. We're always here. Moen Hatley PC. We truly are your partner in divorce and estate planning. And thank you for taking the time to listen to us today.
Proper planning prevents
poor preparation. Charles, you were twitchy. Thank you, Rebecca.
You're welcome. You were like,
hey, Nick, will you make sure to copy this hyperlink out of the chat that she put in there?
Thank you for tuning into our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.